January the 19th, 2016 to order. If we could ask Commissioner Kendrick for invocation.
Sure. Let's pray. Heavenly Father, thank you for this day. We thank you, Lord, for this meeting that we're having. We'd ask that you watch over us, guide us, help us to make the right decisions. Watch over our troops that are at home and in foreign lands. Be with all of our citizens of Person County and watch over them. Amen.
Commissioner Clayton, if you would lead us in the pledge, I'd appreciate it.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. You have the agenda before you. Is there anybody that wants to make any adjustments? If not, do I hear a motion we accept it as presented?
So moved.
All in favor?
Aye.
Any opposed? All right. We've got a recognition here for a longtime employee, Mr. Bob Clay. If you would come forward, please. I'd like to read this resolution of appreciation. Robert Bob Clay has served the people of Person County during his tenure working for Person County Emergency Medical Services as a shift supervisor. Bob Clay has served the citizens of Person County with honor, integrity, sincerity, and dedication, providing accurate, concise services for 25 years, August 1990 through December of 2015. Bob Clay has earned the respect and admiration of all who have known him, worked with him throughout his career. The County of Person recognizes that many contributions Bob Clay has made to the county and offers him sincere best wishes for his retirement. Now therefore, I, David Newell Sr., Chairman of Person County Board of Commissioners, do hereby extend this resolution of appreciation to Bob Clay for continually striving to make Roxboro and Person County a better place to live and work. Adopted the 19th day of January 2016. Thank you, Mr. Clay.
Thank you very much.
Okay, we got to meet on these circumstances and not.
It is. It's a much better way to be.
Thank you, Bob.
Bob, you ain't never really been short on words, so you more than welcome to selfie.
Okay, I'll take over you. How many is a few? Okay, well, it was a blessing for me to come to work for Person County Emergency Services. It takes a different kind of person to respond to the calls for help, and it's so like anybody involved in public safety. They go out in the middle of the night at the worst time and the worst weather to help and assist the citizens of the county. It's been a long time. I inherited a Person County family, and it's like an extended family. And we relied on each other and helped each other and stuff, just like we did the citizens of the county. I just want to thank everybody who's helped me along the way. Thank you, honey, and everybody up and down this hallway on the second floor, because they can tell you, and I could bring the mail over, and it'd take me 10 minutes to get from one end to the other. And I appreciate it. Y'all take care of it. Take care of Person County EMS and make it better.
Thank you.
Thank you.
All right, informal comments. You say we don't have any? All right, moving along. Item number 2, consent agenda. Has anybody got anything they want to talk about referring to?
Move for approval.
Any discussion? All in favor say aye. Aye. Any opposed? All right, item number 3, stormwater. Ms. Sybil, you could help us with that.
Good morning, Commissioners. As we do each year, we try to give you an update about stormwater, and this year's no different. So today we have two sets of consultants who will be here before you. The first is Henrietta Locklear from Raft Ellis, and she is our stormwater administrator. And if you'll recall, we have a joint utility agreement with Granville County and those municipalities, and that is really the domain of Ms. Locklear. The second group of consultants we have this morning is the folks from the UNRBA. We have Forrest Westall and we have Jay Sober, and they will be giving you an update about the UNRBA activities. So with that, I will hand it over to Ms. Locklear.
Thank you, Sybil. Thanks for having me here today. It's been a while since I spoke with you, and I haven't appeared before some of you before. So thanks for having me. And just to echo what Sybil said, the county works cooperatively with Granville County, Butner, Creedmoor, and STEM to provide some stormwater services. And we've been doing that together for several years now. And I'm happy to say that that partnership is going very well, and it's enabled us to have a voice with organizations like the Upper Neuse River Basin Association, to represent us as a group, along with the other jurisdictions in that association in particular, and to also provide services as efficiently as possible for the group of jurisdictions. So I've given you a short write-up that you can read either now or after the presentation, just to review some of the services that we provide. To start with, every year the county bills utility fees for stormwater on the county tax bill. And so one of my responsibilities is to develop the bill file to accurately charge customers for those services each year, and to provide that to to Russell Jones. And in 2015 we had new imagery, so that update process was a little bit more comprehensive than usual. It allowed us to update a number of fees in the county. This year we had no appeals of the fee in Person County, which I think indicates that we're getting settled in very well. We had a couple customer inquiries, but nothing that resulted in a change of fees. And in the county, you may recall that we have the opportunity to provide folks who provide stormwater treatment on their properties with a credit on that fee, and we have one of those in Person County that was approved last year. You have a high collections rate. I can't take any credit for that. That's Russell Jones, but it's almost 97% of fees. So that's our annual billing. So to touch on some of the other activities, some of our major activities that I'm responsible for are related to the Falls rules. The first program being the existing development program, which you may recall is the program where the county will have the responsibility for providing treatment for nitrogen and phosphorus for development that occurred between the beginning of 2007 and mid-2012. So one of the tasks is to figure out how much new nitrogen and phosphorus was attributable to that development. So we've been working with the other jurisdictions and the state on developing the methodology for that number, which eventually the county will be responsible for treating. And we have made a lot of progress with the state on that, trying to get the most beneficial calculation for the county for that program. And when we have an approval for that methodology and the amount of nutrients, then we'll also be developing a program for treating those nutrients. And again, we're striving to provide the most efficient treatment for the county. So in other words, we want to find the most inexpensive ways to treat those nutrients. in the watershed. And that likely will involve partnerships with our other sister jurisdictions to place BMPs in the most, which are best management practices, probably close to the lake. That will get the most bang for the buck there. Secondly, I'll talk about the new development program. This might be the program that you as commissioners hear the most about because it affects development in Person County. I have a subcontractor, a consulting engineer who provides engineering review of plans where that's needed for development plans in the county. This past year, we had, this paper says two, but we actually had 3 developments that required engineering review out of a very great many applications that came into the county. So only a subset of development plans have to have review, and that's provided by my subcontractor. And the customers pay hourly for his time, rather than you all having to have a dedicated resource at the county for that service. We have strived to provide some certainty for developments in Person County, which, as you know, is an important part of encouraging development. So we have, a development checklist and a very set way that those development reviews occur, and try to provide them expeditiously as possible. I'll skip down to the bottom of my little sheet that I gave you on the second page. I also provide coordination activities for the 5 jurisdictions, including developing the annual work plans, which lays out the budgetary items that you'll see early this year, and also the opportunities for coordination among the jurisdictions. So I'm going to be meeting with Sybil at the end of the month, and she'll be meeting with her staff subsequently. I will come and speak to you anytime you wish, so just let me know if you ever want to hear about stormwater activities. And then importantly, I represent the county with the Upper Neuse River Basin Association as a technical resource. So the UNRBA has a lot of very technical work that's going on, and I go to a number of meetings to help represent the county's interests in those meetings. Forrest and Jay are going to talk a little bit more about those efforts, so I don't want to cover them in detail here. But I'm there at those meetings and trying to represent what's best for the county in all of those technical discussions. In addition, we had the opportunity to provide comments to the state on the falls rules this year. I know that you as a board submitted one comment asking to raise the disturbance threshold for coverage of residential developments under the falls rules. So you submitted a resolution. I also coordinated a number of other comments with the 5 jurisdictions that we submitted to the state to be more favorable to our group of jurisdictions. And then lastly, I was also involved in the Upper Neuse River Basin Association development of comments, and have met with the state about those comments, as I think Forrest and Jay will also describe. So we have the opportunity to make a difference in those rules and to make sure that they're structured most appropriately for us. And so we're taking advantage of that opportunity at this time. With that, I think I'll pass it on to Forrest unless you want to ask questions now.
Have you, the request that you sent in to increase the lot size from ½ acre to an acre, has that been approved?
It is not. It's a pretty long process that those falls rules changes. But we had the opportunity to speak with the state about, why that's important to us, and in the draft set of rule changes that the state staff have submitted to the Environmental Management Committee, that is one of 2 options that they've proposed for changing that language. So to change it from ½ acre to an acre is one option, and we've strongly expressed support for that option. And then there's another option that the state is looking at as well. But
Well, who will actually make this decision? EPA?
No, it will go through the state rules review process. So there's a rules review committee that will be the ones that make that decision. And, we'll be in contact with them this whole time to,
Is Larry Yarborough on that rules committee?
I don't know, do you know? No. He's not.
When you say long process, what time frame?
I believe that it has to be complete by 2018. Is that correct? Right. So we have, this intervening period where we're still under the
So the rules
current
committee
rules.
doesn't meet to 2018?
No, they're meeting now, but they are reviewing a large number of rules, not only the falls rules. And so I think our rules are slated to come up, they're not first on the list. So, but the session law demands that process be done by 18.
Can you get us a list of people on that committee?
Yes, sure.
Ms. Locklear, you'll have
Yes.
to excuse my ignorance because I've not been as intimately involved in this as
Right.
some of the other commissioners are, but in one of your statements here, it says, we're looking at identified developments that occurred from 2006 through 2012,
Right.
and going over how much relevant data that we have for this period. We've already started doing testing that's been approved. I assume it's been approved, correct? The testing that we're doing. So we know that the nutrient levels, the nitrogen levels are dropping. We've seen that in the testing. The phosphorus is up a little bit. So since we know where we're at on these two levels, why do we need to continue to look at the developments between 2006 and 2012?
Well, we're seeing that the testing results, as you say, and Forrest is going to talk a little bit about what we're going to do with those data. Those data are going to affect what are called stage 2 of the rules, primarily, where stage 1, we have to reduce the nutrients from that period that you've talked about. And then in stage 2, we basically have to reduce it even further. So there are a lot of people that believe that, either we don't need to reduce them as much as the law says, or that even if we do that, we can't make the lake come into compliance with the rule, and so we need to take another path. However, at this time, we don't have a way to change that stage 1 requirement where we reduce the nitrogen and phosphorus from that level. And so essentially we need to go with it as
Your
planned.
question is why are we looking at 2006 to 2012?
That's
It's
correct.
because it was written in the rules and the regulations.
Right.
But was it passed in the state law from 2006, or was it in the rules of environmental management?
It's in
The
in
rules. The rules required that. There was a lot of objection to that, but the rules did require it. That's why they're looking at that date that you're talking about. There's been some controversy about that, so Forrest and them can talk some more about that, but I understand your answer, but his question actually was why are we going back looking at that?
Well, I realized that it was environmental management had put that in the stage 1 rules, but as I said before, we've already shown that the nitrogen levels are down, the phosphorus levels are up a little bit. If we already know those two things, why are we still wasting our time on going back to the developments between 2006 and 2012? Why wouldn't we, and again, I apologize, I didn't know enough about it until I started reading prior to this meeting. Why didn't we ask that this be one of the things that we changed in the Rules Committee when we sent our one request down?
Well, I believe that the answer would be that although the nitrogen and phosphorus are coming down, it likely wouldn't be sufficient to help the lake come into compliance with just what's happened so far. I think that's one part of it. Another part might be that as we're changing the rules, we still are not able to, we're still under the current rules. And so right now those are the requirements that we have to comply with. I think that Forrest and Jay will talk a little bit about some of the things that we're doing in connection with the existing development requirements. One of them is that we have, when we went into this process, we did not even have a very efficient way to treat those nutrients that we were required to for 2006 to 12. And one of the things we're doing is to try to spend the county's money as efficiently as possible by giving us a lot of options to do that. So while those requirements may change in the future, we're focused right now on trying to do what we're required to do in the most efficient way possible. So I can't speak to why the commissioners only submitted one comment. It was a very important comment to submit.
Oh, I agree with that.
But we've also, under separate processes, been able to provide additional comments that are more comprehensive. Want to go ahead?
Good morning. I'm Forrest Westall. I'm the Executive Director of the Upper Neuse River Basin Association. Appreciate the questions that you had. I'll try to stand back from the microphone. I'm a preacher, so I may get wound up. And this is very important to me. I know it's important to Person County. I took the position in 2012 because I believe that public policy and environmental protection is important. I believe that balancing that with the needs of local government and the demands on you all and other local governments in the watershed is extremely important. And, I'm your advocate. I'm the advocate for all 14 governments in the watershed. Henrietta mentioned that we've been dealing with the state. I set up a meeting last week to meet with the director of the division and all of his staff to tell them how important the comments we provided were to the communities here. And we specifically talked about the moving 1/2 acre to an acre, and I think that's very important. But I'll just mention that. We passed out a handout. I just want to let you know that the UNRBA is focused on the rules. We're focused on the Stage 2 rules, and we are helping with the Stage 1 rules that Henrietta alluded to. That's called the reexamination process, which basically means we don't think the rules properly reflect what's going on in the watershed. We don't think the rules properly reflect what needs to be done. We don't think the rules are balanced or fair. We're working through that using scientific information to make a real case with the state. Whatever we may believe about the rules, and I've been in this stuff for 40 years, and whatever we may believe about the rules, and we may think we have the right answer, people are not necessarily moved just by my opinion. I deal with that in church, so they're not necessarily just swayed by my opinion. They need evidence and data, and we're in the process of collecting that evidence and data to come back with a reexamination process that I think is going to substantially change the rules for Stage 2. So that's, and the supporting program for that is our monitoring program. Jay's going to talk about that in a minute. Worked with Jay for 40 years. He worked for the agency. He now is outside the agency. Jay has a significant amount of common sense in monitoring, and he's been extremely helpful in focusing our monitoring program and helping me out and the UNRBA and you to come up with good data that will support changes in the rules that we think will be beneficial to the local governments, not only in terms of cost, but also in development and in future requirements.
When you speak about agency, you talking about EPA?
No, talking about the North Carolina Department of Environmental Quality. And right now that program is run through them. EPA oversights that program. EPA is well aware of Falls Lake. They're well aware of what the state's doing. So far, because the state has taken specific action, the EPA's kept their hands off of it.
They have the authority delegated to them by EPA to handle this. The state of North Carolina took that responsibility.
Yeah, I just wanted to clarify who we were
Right.
talking
Right,
about.
and I mean, and I personally believe that's a good thing, because I'd rather work with folks in the state than EPA. I work with EPA a lot. They're not easy to work with. And so, you know, I like to work with the state, because they at least have better knowledge. The closer you get to the problem, the more reasonable people are and the more knowledge they have. That's why I like working with local governments. Henrietta mentioned that we're looking at developing some better ways of reducing nutrients, best management practices, things that will be more cost-effective, things that will be less burdensome. The city of Durham right now is testing a technology that we think is very promising. They're pumping water out of the lake in a small demonstration project and running it through a treatment system to remove the nutrients from it, and then putting that water back in the lake. Preliminary cost estimates indicates that's the most cost-effective way to reduce nutrients in the lake, as opposed to doing things on the ground in the watershed. And so that's encouraging. You know, it's not just moving the nutrients around; it is removing the nutrients, which is real improvement. So we think that's going to be helpful. The development of alternative regulatory options is important too. This is a dammed up river. It wasn't, y'all didn't ask for it to be dammed up. Not many people in the watershed asked for it to be dammed up. The Corps of Engineers dammed it up. I was there in 1982 when they closed the gates. And because it's a dammed up river, it's a drowned southern river. Reservoirs that are done like that throughout the southeast all have issues with algae, every single one of them. There's none of them that are pristine. They're not like northern lakes. They're not like the Finger Lakes up in Michigan. They're just not, they have natural high temperatures, nutrients going into them. So there's only so much that can be done reasonably in this watershed to improve water quality in that lake. There's only so much. Our monitoring program is going to give us good tools to demonstrate legally and regulatorily that there's only so much the folks in the watershed can do, and we don't need to require them to do things that are going to not have benefit in the lake. Let's don't throw money at an issue. Let's try to get reasonable about what we need to do in that watershed and what can be done to improve water quality to the maximum degree, and not place an undue burden on the folks in the watershed. Henrietta mentioned there's kind of an interim process. The legislature and passed a bill in 2011, I think, requiring the state to look at all its regulations. This is the regulatory review process. And North Carolina's been involved. That all the rules that the Department of Environmental Quality have on the record have to be reviewed. That includes the Falls Lake rules. We have identified several things. The county identified the 1 acre. We've identified the schedule. We believe the schedule is too short. We believe that we should delay that. The stage 1 existing development that's in stage 1 was placed in those rules to a great degree because of the consensus principles that were worked on back in 2009, 2010 in the watershed. And those agreements went into the rules. Existing development, the rollback of nutrients for that period 2006 to 2012, that was supposed to have gone into effect in 2013. Through our intervention with the State Department and the Environmental Management Commission, which is the policy board that passes these rules, we've delayed that. Those rules have not come into effect yet. They will not go into effect until probably somewhere around 2017, 2018. Because we're doing this study to determine better ways to reduce nutrients, the state has agreed to allow us to finish that study before they go back to the Environmental Management Commission and start the stage 1 existing development. That's looking like it's going to be somewhere around 2021 before that actually gets started. So we're somewhere around that point you all are going to be required to roll back those nutrients. But we've put that off. We've also asked for the stage 2 rules to be shifted from 2026, the beginning point, to 2031. We believe that's a more reasonable date in order to do the work and finish up our study, so we can change the rules again before they go into effect. In summary, the UNRBA is really working to produce information that will strengthen us. This is not a research project. We're not here to try to find out things just for the sake of of academic study. This is to find solutions that will change public policy. And if I could, I'm going to come back up at the end, if that's okay. And Jay was going to summarize the monitoring program, if that's okay. Jay?
I would like to ask one question before you go. When I first came on the board, we were talking about this, it just got implemented. And it was my understanding at the time that the process would be for us to collect data and determine the severity of what was coming out of Person County. And then I assume that's what we've been working towards.
Yes.
Okay. Well, okay.
Okay. And I can address that further. I mean, that's a big, important part of what we're doing with Jay.
Thank you, Forrest. Commissioners, I'd like to draw your attention to slide number 6 on your handout. I'm going to be speaking from these slides. I don't expect you to be able to read all of this, and I'm not going to spend a lot of time boring you with all these technical details and pathways. Rather, I want to make sure that you have an understanding of what we're doing with the monitoring program and why we're doing what we do with the monitoring program. In part because it's expensive to conduct water quality testing, but it's also important that when we go to the state and EPA with suggestions for changing these rules, that we are on the absolute best scientific footage to provide a foundation for the comments that we are going to make, and that our scientific assessments and our water quality monitoring programs and our predictive computer modeling activities are of very acceptable quality and go beyond that of the monitoring and the modeling that has been performed by the state to date. We're not out there monitoring the waters draining into Falls Lake like the state is. The state, under the Clean Water Act, is required to test all the waters in the state to see if they are meeting the state's water quality standards as adopted through a Clean Water Act federal mandate. The water quality standards are something sort of like the 10 Commandments. These are the basic foundations on what the waters are expected to do when they're tested. It's kind of like going to the doctor and getting your laboratory test results. There's certain levels you don't want to go above, and those are our water quality standards. The most important water quality standard as it relates to Falls Reservoir is the chlorophyll A standard, which is a measure of the amount of algae in the lake. We've designed the monitoring programs to support and gather the information necessary to plug into predictive water quality models that are all done on a computer. These models simulate how the lake actually functions, how it operates. We build these models in order to compare them to real data and to test whether or not they are a good fit of our understanding on how the lake works. We then take these water quality predictive models and use them to run various scenarios. In other words, we ask the model questions. How much nitrogen do we need to cut back? Where should we cut it back from? How much phosphorus do we need to cut back? Have we cut back enough? Where's the load coming from of all these nutrients? What's the most efficient way for us to reduce those loads? And then we take those modeling analysis and those scenarios, and then we apply it to the rules. And we take that data and knowledge and the modeling results, and we say, what's the most efficient, effective way to bring this lake into compliance with the 10 Commandments water quality standards based on the best available science. Now, I ran the state's water quality monitoring programs for lakes in the state since about 1981, and before that, I was there long before Falls Lake was built. We knew that Falls Lake would have water quality problems. We knew that it would not meet water quality standards. But through the regulatory process, it was determined that the benefits of Falls Reservoir outweighed the problems of the algae that were going to be existing there. If you will, we kind of kicked this water quality problem down the street and said, we'll deal with that later. We needed the water for drinking water supplies, we needed flood control, we needed the recreational activities, all good things. But we knew we were going to have to deal with these algae issues and the chlorophyll A issues. If you'll turn your sheet over, I'll give you an example of what a water quality model looks like. There's a picture there I've borrowed from a good friend of mine, Dr. Hans Pearl at the UNC Institute of Marine Sciences. It gives you a conceptual model. Pictures of water running off the land, atmospheric, nitrogen coming in from precipitation, and internal processes going on, nutrients coming in from bottom sediments and things like that, urban runoff, impervious surfaces. All of that is displayed as a picture model. If you go to the next slide, you're going to see a very confusing group of pathways. Lots of moving pieces, lots of moving parts. How does the algae or phytoplankton grow? Where does it get its nutrients from? Is it related to how quick the water moves through the lake? The retention time in the lake? Lots of different scientific issues and water quality parameters that we are testing as part of our monitoring program to take these two concepts and build them into a computer model that we can use to run these different scenarios. And we can build that based on the improvements in our monitoring program and the improvements in our modeling so that those issues will not be second-guessed by the state or EPA when we begin to apply those to the rules and our management strategies. There's lots of factors that control how much algae we're growing or how much chlorophyll. If you will, it's very similar to farming in reverse. What a farmer wants to do is grow a lot of crops. He wants a very productive field. That's not what we want in Falls Lake in order to be able to meet the chlorophyll A water quality standard. It's harder than that. What we want to do is do the reverse. We want to make it less productive. We want to grow less algae. But there's also different types of algae, just like there is on a farm field. We might be interested in growing soybeans, but we're concerned about the weeds that are in there. The weeds would be blue-green algae, the kind of algae we don't want. The soybeans would be green algae, the good kind of algae that fish and all of the other good critters in the lake actually eat. So you want a certain amount of productivity, but not too much. Well, imagine how difficult it is to take a very productive farm field and reduce that down to get the nutrients out of the soil so you're not growing too much, whether it's coming from urban runoff or whether it's coming from municipal treatment plants. It's a difficult task. All of our monitoring is geared to answer these questions, plug them into models so that we've got the best footing possible to apply to our rules and apply to changes in those rules. The next to the last slide you see on your handout is a picture of our water quality testing stations. Those stations that we have established to get information on how much nitrogen and phosphorus and other parameters are going into the lake for us to plug into these models. The yellow dots, and I know they're small, I've got a bigger handout of this and all the monitoring stations. If you're interested in that, I'll be glad to distribute them. But we also have orange dots on this map. Those dots are set up and being monitored to establish jurisdictional boundary information. How many nutrients, how many pounds of nutrients are coming in from all of the different jurisdictions. You notice there's at least half a dozen sites up there in Person County. Help us find out where those nutrients are coming from so that at the end of the day, the responsible parties know how much they have to cut back, where it needs to come back from, and how they relate to the other municipalities, towns, and other managers along the way. I think I'll turn it back over to Forrest, and I'll wait to answer any of your technical questions after he concludes. But the name of the game is, back when I was running the monitoring program for the state, as you can imagine, there's 100 counties out there. There's over 100,000 miles worth of rivers and streams. There's over 170 lakes in the state. Their resources to conduct state-of-the-art scientific monitoring were not very large. Through the UNRBA activities, through the contributions of local governments, we have greatly enhanced the monitoring programs. We've greatly enhanced the science. We intend to greatly enhance the modeling that will lead to better rules.
Well, I just wanted to wrap up, and the last slide that was on there shows a balance beam on it. And like a lot of things in life, you don't get everything you want. If you're married, you understand that. You have to compromise on some things. And I know that these rules, the way they're laid out right now, represent a tremendous burden, a heavy burden for the entire watershed. Estimates, even by the state's own estimate, to meet all the requirements in there will be well above $1 billion. That's an excessive amount of money for folks in the watershed to have to deal with, and it is something that needs to be modulated. It needs to be adjusted. We're doing that. We're working through that process. We are taking the position that the state developed their model with information that was inadequate. They didn't have enough information to do it with. The legislature in 2008 said you will adopt state rules for Falls Lake. You will reduce nutrients going in. So the state put together the best model they could during that period of time, and those rules were passed. What I would say is that, as Jay mentioned, they have limited resources. We can either let the state determine or EPA determine what we need to do, or we can take the responsibility and put together our information and make our own position on what needs to be done. Person County is an extremely important part of this effort, an extremely important part of the participation in this effort, and it is something that I take extremely seriously, and I'm working as hard as I can to get this pushed forward so that we can make some changes to these rules that will be beneficial to the watershed.
Are you working with the lawyer in Granville County?
The lawyer, Jim Wren, or?
Yeah, they got it. Well, who?
Jim Wren.
Yeah.
Yeah, Jim comes to all of our meetings. Been with Jim. Jim and I have, we came up and met with a person, Roxborough Home Builders Association, sometime back.
Yeah, well, that's what I'm getting at. At that meeting, I was pretty much convinced that he wasn't really working for Person County. He was more or less in favor of taking care of Wake County. And, I guess my biggest question to you is, do we have enough documentation to show what the contamination is coming out of Person County?
We have preliminary documentation. We have.
All right,
we
is it
have
good,
some-
bad, ugly, or what?
Well, at this point, we haven't gotten to the point of comparing what the state projected would be coming out of Person County versus what we're measuring out of Person County. We've been monitoring since August of 2014, so we have a little over a year's worth of data. This program is designed for 4 to 5 years of monitoring. The numbers that Commissioner Kendrick was referencing came out with a report from the state based on limited information that said they see a reduction in nitrogen in the lake and some increase in phosphorus. What I would say in response to that is this lake is a natural system. It responds from one time to the other. This last year was a wet year, so the loading in the watershed is going to be higher because the rainfall pushes the nutrients out. Person County has a limited impact on the lake. It's in the top of the watershed. It's much further from the lake, but it does have an impact. Some of the nutrients that leave the ground and leave the rooftops and paved areas and fields that are in Person County get to the lake. We've already done a calculation of that percentage from each one of the jurisdictions, what percentage of the nutrients that originate in those jurisdictions actually get to the lake. Well, for Person County, it's much less than 100%. It's on the order of, for phosphorus, it's much lower. It's more like 60-70%. For nitrogen, it's 70-80% get to the lake. So that's going to be factored in our discussions and conversations about what needs to be done. That's why I'm excited about this algae turf scrubber test, because that addresses the problem in the lake, because building stuff on the ground is a lot more expensive. It's a lot more expensive to capture runoff, treat runoff, and allow the clean water to be discharged. It would be better to reduce the nutrients in the lake, since that is our objective, is to improving water quality in the lake.
Wouldn't it be a lot easier again, excuse my ignorance, I've just gotten into this a little bit, but on your website, the UNRBA website, it shows the different tributaries that are feeding into the Lake Mickey Dam system. And you got the 6 different monitoring stations that actually come into the Lake Mickey Dam area. If we take those 6 monitoring stations and measure those and then measure what's coming out on this backside of the Lake Mickey Dam, wouldn't we be able to more closely show what the residents of Person County are putting into the lake? Because I would assume, I'm not a scientist, never played one on TV or anything, but if we got stuff that's feeding into Lake Mickey Dam, then Lake Mickey should be taking most of the sediment, and the regulations that Lake Mickey Dam has to work under, I've read some of those things weren't in place when the new water rules were put into effect, and so they don't have to dispel a lot of water like a lot of other dams do. So I would think that the significance of Person County nutrients are stopping at Lake Mickey, which we don't want to pollute any waters, but it seems like our effect on Falls Lake is going to be a lot more minimal than any other group that's feeding into Falls Lake.
Well, I mean, if you look at and we have more monitoring stations in Person County than any other county, by the way, because Jimmy said we had to have more in there, so we put more in there. Those 6 monitoring stations that are in Person County will do exactly as you said. They will measure the amount of loading coming off of Person County, and it will also measure the amount of nutrients coming out of Lake Mickey. And therefore, we'll be able to show what reduction is in Lake Mickey. We've already projected that, and as I was saying, there's another report on the website that talks about delivery factors.
Right.
And that report says that based on where you are in the watershed, what you have to go through has an impact on how much actually gets delivered to the lake. For phosphorus is oftentimes associated with sediment. So when you go through Lake Mickey or any other impoundment, and there's several other tributaries that have impoundments on them, that when you go through there, a lot of the phosphorus is removed by that pre-impoundment before it goes into the lake itself. But not all of them are eliminated. And again, it's like anything else. If you're going to appropriately say Durham, which is probably 100% of their nutrients are going in, if they must reduce their nutrients at some level, then Person County must reduce its nutrients at some level. Your level of reduction will be significantly less than the city of Durham because they have big urban areas that are going to produce a lot more nutrients than Person County does. And so I think we're going to be in a much better position than the state ever was because they didn't have any of this monitoring data. When they did the rules, they didn't have the monitoring data in the jurisdictional areas like we do. They didn't have the information on stormwater events, which we're monitoring. They didn't have a full complement of how the nutrients get into the lake. And so, we're strengthening our case over and over as to where the nutrients are coming from and what benefit will it be if Person County was to reduce their nutrients that are getting in by 50%? What would be that benefit? If we have a modeling tool that allows us to simulate that, we can change that model and say, what happens if you reduce your nutrients by 20%? What if you reduce them at 50%? What's the cost of reducing nutrients by 20% versus 50%? How much are you buying? Our preliminary cost indications are that these rules are more expensive per household in this watershed than they should be, and they're some of the most expensive rules in the country. So we've already done that comparison. That's in one of the reports on the website as well.
Okay, that goes to my second question. In the most recent Supreme Court ruling on the EPA agency can't turn a blind eye to the cost of regulatory overreach. Where are we in looking at the recent Supreme Court ruling and the cost that's, to me, way overreaching? You just stated that, and the cost to each of our municipalities.
Well, I mean, I don't know how many folks on here are attorneys. One attorney at least. I don't know other attorneys, but the challenges against particular rules. Obviously, most of the court cases, if they take a specific challenge on a specific rule, then they rule on that ruling. We do track Supreme Court cases related to environmental actions. We do see some beneficial decisions being made. We also see some that are not so beneficial. And so I think, overreach is a part of any concern about government based on what the benefit is to the public. Government's created to help and benefit the taxpayers, and therefore, if it doesn't do that, then it's an overreach. And I agree with that as a concept and as a policy matter. But at the same time, when I went to work in 1976, there were raw discharges in the state. There were extremely bad situations. We've made a lot of progress. It cost a lot of money, but it's going to cost a lot more money to go way beyond that. And that's one of the reasons why I think we need to step back. We need to take a good look at this, and we need to say what is reasonable versus what can be done technologically. Right now, we don't think that I have the numbers on the slides there. Stage 2 requires 40% reduction in nitrogen, 77% reduction in phosphorus. Our preliminary calculations by our engineers that are working for the UNRBA is that 77% phosphorus reduction on developed land in the watershed is impossible. There's not any technologies that can do that. So we already believe we have a strong case for saying that doesn't make any sense. Our preliminary monitoring shows that probably 77% is way too high, even for what needs to be done to meet 40 micrograms per liter of chlorophyll A in the upper lake. We've already shown that that is 40%, may be technologically achievable, but it's not economic. It costs way too much for the benefits. We projected the benefits of these rules based on standard engineering procedures, and we believe the benefits are way below what the costs are. That lays a foundation for these other regulatory approaches. What I'm saying is we need to go back to the regulatory people and make a legal argument, and there will be a time to bring in attorneys, and there will be a time to provide legal action. But I think at this point, until we get our information together on a scientific basis, we're not going to be able to cross that bridge until we get there.
Are any of the regulations achievable?
Yeah, I think the ones that for stage 1 are achievable. The consensus principles that were worked on by the folks in the watershed, there was negotiations before the rules were passed. The folks wanted, everybody acknowledged that the city of Raleigh's water supply is important. So stage 1 rules are to protect the lower part of the lake so that where the intake is, that it will meet the water quality standards. I think we've already really, the last 2 measurements that DWR did on that showed that the lake was in compliance in the lower section. It's not in compliance in the upper section. So the reason the folks agreed to that is because that was a direct impact to the water quality that the city of Raleigh was getting to treat, to distribute to its citizens. So that was the reason the stage 2 were in there. The wastewater treatment plants for South Granville Water, Sewer, and District are under construction to meet the 20 and the 40%, 20% nitrogen, 40% phosphorus. So is Hillsborough already in. City of Durham is already meeting those requirements. And so there's already been those improvements on the ground. For existing development, stage 1, and that goes back to the question that was raised by the commissioner concerning rolling back. The model that DWR developed was developed in 2006 based on that data. So that was what they call the baseline year. And so the first stage of the rules is to roll back loading for any new development that occurred between 2006 and 2012. So that's where the accounting comes from, is how much development was in Person County in 2006, how much new development occurred up to 2012. Whatever that increment was, that was the increase in nutrients from new development. And the stage 1 requirements requires that to be rolled back. Based on what I've seen in the watershed, those are going to be fairly moderate reductions, particularly for rural areas. The city of Durham's got a much bigger hill to climb, but the city of Durham puts a lot more money into the UNRBA in terms of what we're doing. So I think stage 1 is achievable, but I don't think we ought to begin existing development offsets until we finish our project, until we come up with better ways to do it, so that the jurisdictions use their local money in the most cost-effective way possible. So we've delayed that implementation. It was supposed to begin in 2013. It's not implemented yet. It probably will not be implemented until 2018. and maybe even later, because it depends on the state's consideration of what we submit to them. And we're finishing our project up about the middle of this year, and that'll be submitted to the state. They have to approve it, and then they'll have to go back to the Environmental Management Commission and get approval for how local governments are to develop their local programs to meet that offset.
Who built Falls Lake
The Corps of Engineers.
as flood control?
As flood control, water supply, recreation, habitat, water quality.
Well, why didn't they build it right?
Well, it's built right. I mean, it's built,
Not for water supplies, no.
well, I mean, if you're talking about why was it not built so it wouldn't have problems with algae, it's impossible. You can't dam up a southern river without getting algae problems. I've seen every lake that's in a southern Piedmont lake. Now, there's some up in the mountains, Nantahala and some of those other lakes, even Lake James is kind of on the transition. All of those lakes at times have excessive algae growth in them. The blue-greens that Jay was talking about, those are in there. If you look at the Catawba chain, from Roadhiss, Hickory, all the way down, those lakes have issues, and they're going to be in High Rock Lake on the Yadkin has issues. All of the lakes in there have issues. So there really was no way to build a reservoir on the Neuse River without it having algae problems. And I was with the agency during part of the time that the agency studied that, and what Jay said was our projections were that the chlorophyll A standard, which was the same in 1976 as it is today, would not be met. And our advice to the powers that be and the Corps of Engineers was don't build that reservoir because of that water quality issue. But as Jay said, you know, those are political decisions. They're not just technical decisions. And the government that was in place, the administration and the legislature that was in place then said we need to go ahead and construct this reservoir for all of the benefits it has, understanding that it may have issues down the road. And that did kick the can down the road. And, you know, that's unfortunate, but that was not something that now can be changed. I mean, that lake is there. It's a reality.
So explain to the public what we have going on with Falls Lake and then what they hear on the news and everything about Jordan Lake.
Well, what we have in Falls Lake, similar situations in Jordan Lake. What we have in Jordan Lake is the folks in Jordan Lake are delaying, in my mind, the inevitable of having to do something. And they're testing those mixers out there, the solar bees, and I wish they would work. I mean, I'd be glad if they worked, but they're not cheap. Even the test was $1.2 million. I sat down and did a quick calculation. You're talking about several tens or hundreds of $millions to put enough on the lake to actually do any good. The first year of the study, the state did, their conclusion was that the algae in the area where they're treating in Jordan was no different than the algae anywhere else in the lake. So the indication is that those solar bees did not change the water quality conditions. So, you know, that's one of the things, and they've delayed it again to go through that process. But in my mind, at some point, EPA is going to step in and require some reductions in that watershed. The point sources are already doing it. The wastewater treatment plants in Greensboro, in Burlington, they're already reducing their nutrients through the addition of treatment systems. They're not dealing with the issue of runoff the way they should be. And as a result, I think they're just delaying the inevitable. I believe it is more judicious and more beneficial to the watershed to move forward and to provide evidence and data that settles the issue in Falls and allows us to go forward from there. It's going to continue to be debated on and on about that. And the political winds change. Right now we've got a conservative legislature in. It's different than it was in 2008. I acknowledge that. Everybody acknowledges it. It may change again. It may stay the way it is from now. It may get more conservative. But that won't change the lake. The lake is there. Chlorophyll A is not going to be below 40 on a continuous basis in the upper part of this lake. That's why we do this study. We demonstrate that it can't be done. Then I think we're going to ask for legal action to change the way that we regulate nutrients so that we get the best we can for the cost associated with it, and not try to do impossible things and spend a big pile of money just to throw money at the issue. So that's my view of it. I wouldn't advocate anything else other than trying to do the best for this watershed. I think the rules are an overreach, but I also think that the rules are the rules, and we need to change them through a scientific process and a legal process. And that's why I think the UNRBA has the right approach to that. I think we can settle it.
Yeah, but my question earlier about the Supreme Court ruling, now that it's fresh in the minds of everyone, why wouldn't we be looking at that now versus waiting later down the road as we kick the can, number one. Number two, I certainly don't want dirty air, dirty water, as most Republicans are portrayed to want, but I also am tasked with making sure that our citizens of Person County are looked after also. One of the things that's, well, I'll tell you what, I'll let you answer the question about the Supreme Court first, and then I'll go to my next question.
Well, I mean, I think I would like to read, in detail that decision. Again, in my experience, and I've been involved in a lot of court cases, and I've been expert testimony, and I've done all of those things. My general indication from the attorneys that I know is you have to have a specific challenge to a rule. So in order for there to be a challenge to the rules that as they exist today, then someone who is aggrieved will have to file a lawsuit for that. And as most attorneys will tell you, that you ask them, can you sue? And the answer is yes, you can always sue. But the question is, can you win? I think based on the full history of the Supreme Court and the decisions made both in North Carolina and at the federal level, I don't think that's a guarantee. I don't think you will guarantee to show that to be the case. And in fact, in many cases, it is deferred to EPA and said EPA has done what it needs to do, and we're not going to substitute the court's judgment in the place of EPA's judgment. So I don't know what the outcome would be if you challenge the rules, but again, you'll end up spending a whole lot of money on that as well. That's not an easy process either.
We're already spending a lot of money.
Well, comparatively though, I mean, for every dollar that Person County puts in, the rest of the watershed puts in $14.
Okay. So my second part is related to the citizens of Person County, our builders and our residents. And I went to your UNRBA website, and it looks like you guys were formed in 1996, and this is prior to the Falls Lake watershed issues. And your mission statement says that to preserve the water quality of Upper Neuse River Basin through innovative and cost-effective pollution reduction strategies, and to constitute a forum to cooperate on water supply issues within the Upper Neuse River Basin. Okay, so that, to me, since it was prior to the Falls Lake watershed rules, says to me, and I think some of my citizens of Person County, that we're looking more at the water quality than changing the rules so that we can be more productive in our development and everything. So that's Tracy speaking. I don't know whether or not anybody else up here feels that way or not, but it looks like to me we're more concerned about the rules than we are looking at ways to help our builders and our residents be more productive. So if we send a case to the stormwater group to look at, we're looking at what you can't do versus what you can do. Can you speak to that?
Well, I would say, looking at the history of the UNRBA, I came to work for them in 2012. And in 1996, when they formed, I think it was more on the basis of a general interest in the watershed. At that point, the issues about the lake were known generally in the public, going all the way back to the 70s before the lake was filled. And I think their charge then was much more generic and much broader in terms of what it was looking at. The bylaws were changed in 2011. They hired me in 2012. My number one objective is to look at these rules and to evaluate these rules and to try to get the rules changed to be more reasonable, cost-effective, and balanced for the watershed. That's my charge. I represent those folks that are in there, that are in the watershed, that are affected by these. The local governments in the watershed bear the heaviest burden for having to meet these requirements. And so I think that the focus and the intensity of the UNRBA has changed significantly from its initial stages. And so I think we are focused on helping out within the range of the rules. I mean, I don't think, I'm not ready, or they're not ready to cast aside the rules. We want to make sure that the rules reflect some reasonable level of pollution control. And pollution control, as you were saying, benefits water quality, but we don't want to spend an excessive amount of money on it with little benefit. So I can't really speak to what they were doing in 1996. I can speak to what they're doing in 2016.
I guess my main point is that I haven't got a single call from anyone that says that the process has been painless, that every time that they send something down, that it's long, it's cumbersome, and the people within our county who are asking for these questions to be answered feel like they're having to present information and things that are a lot harder. And it's like we're telling these developers and people who are trying to build what they can't do rather than figuring out for them what we can do.
Well, I can't, again, the UNRBA's charge and what my responsibility is focused on this reexamination process. We did do 2 workshops. The UNRBA sponsored 2 workshops for the people in the watershed implementing the rules. Issues were raised about how the rules were overly burdensome, particularly to single-family lots. We heard those, and because of that, I thought a workshop would be helpful to sit down with folks in the entire watershed to see how they're administering the rules. I administered the North Carolina water quality rules for 30 years. I was a regional supervisor in the Asheville office, and I had to do all of the rules there. And in applying rules, you got to have common sense, and you got to think back to what is the objective of the rule. And I try to do that in every case. And I think you'd find, if you talk to the people I regulated, I was fair. I didn't always agree with them, but I was fair. And I think we talked about how we could work through some of these things, particularly like single-family lots, where they're subdivided by a property owner to give to their family, one lot out there. When I went to the state with this half-acre to acre thing, I said, this doesn't pass the stupid test. I said, we're just doing things that are not reasonable. We need to fix that. And I've worked with Henriette. I've worked with her folks, and I've advised the administrators of these things to be flexible, use as much common sense as you can within the range of the rules. And I think, I think that's helped some. I think changing that from 1/2 to 1 acre will help a lot. But it still boils down to what is the circumstance, what is the situation, what's the accomplishment. The impact from these few single-family lots is minuscule in the watershed. So why would the state create a impediment that was unreasonable for this subdivision? If you're putting in 15 or 20 houses, a little bit different issue than if you're putting in 1 or 2 lots for your daughter or your son. So I mean, I've done everything that I can within that range. I don't implement the rules in the watershed. I do my best to advise, to guide, to discuss, to help, and I told them some things they could do to get around those things, and I think those are things that as a regulator you have to do, because sometimes in the law and the application of rules you lose sight of the overall objective and good common sense. And I read a book once called The Death of Common Sense, and it was a good book because it talked about when the regulators stop thinking, then you get situations of not being able to do things that make sense rather than just following the rules. So that's just that's my opinion and philosophy on that.
Well, maybe my question would be more to Ms. Locklear about because the citizens putting those up are paying the per fee basis on those, and maybe it's more in line with the people that are within our coalition looking at those plans in your group versus in the upper noose, is that they feel like that the people who are reviewing these plans are looking at how we can't do it versus how we can do it. So that's every call that I've gotten related to this is that direction. Nobody has called me and said how good a process and how easy it was.
Okay. Well, I will say that I would seek to have us provide a high level of customer service, and not make things more difficult than they need to be under these rules. So, I would like to address any of those specific instances and, try to provide the best plan review that we can.
I want to just comment on that. When we met with the Home Builders Association, one of the things I talked to some of the folks is give specific examples, give situations where something happened that you don't think is right. We had people saying, well, it's treated differently in Durham County versus this county. And I can't really speak to that without a specific example to take back to those folks. And as I said, we set up workshops after that meeting, and I've pressed very hard. I told the state, I said, I'm not coming back down here and talking to you again until you address this issue. Because I said, this issue is causing all kinds of problems, and we're losing sight of the bigger picture by really agitating people for really no good reason. So I've put as much pressure on them as I know how to do to change that. It is not a quick process, but I believe we will change it. And I believe in the interim, I think the workshops have been helpful, and the discussions have been helpful. And I think it's important to know how frustrated sometimes people are. Henrietta showed me some numbers of all the reviews that came, and I used these with the state for single-family lots. None of them really were required to have a stormwater program. Maybe one out of the whole thing. For peak flow. So what that means is all of those reviews that they paid for didn't generate any real impacts associated with them. So the question is why are we doing those reviews? And we hear folks saying we're having to spend $3,000 or $3,500 for an engineer to look at these. And that's a cost. If you're building a $200,000 house, that's a significant amount of the cost. So why would you spend that money if 95% of the time there's not an issue? That's why the 1 acre disturbed issue has come up. And I'm fairly confident that the state's going to address that. They certainly, if they listen to me, they'll address it.
Okay. Well, thank you. I hope to know a little bit more about this the next time.
Mr. Chairman, can we hear from our representative since he's here?
If that's approval with the board? Yes, sir.
I didn't prepare anything.
Can you speak to House Bill 630?
Which one is that?
Well, your bill that you primary.
I would love to look at some of the stuff. We do have an open conduit in the legislature now to take advantage of some of the stuff that Forrest is talking about. So no, we're gonna let the rep meet with him afterwards to talk some more about this the algae scrub.
The past the House, it's in committee and Senate. Do we know it's going to come out? It's been there since April.
Well, that was in the budget. The Senate put it in the budget, so it was included in the final. The way the Senate did things is they just put everything in one bill. They called it the budget. So yeah, it's in there.
With that, well, in the bill it states some dates on it, like knowing some things by January 1st and some information even in October, and didn't get to the Senate till after that. So I mean,
no, and it's probably not going to meet those timelines. We just had an environmental review commission meeting, and it's not at the top of the list of the studies in that. But as we get more information and then listen to this, I'm interested in pursuing this 1 acre concept. We can definitely push that from the legislative side and out of the Speaker of the House's office.
had you heard any information that we heard today about as far as Person County being such a minimum impact on the lake? Was there a thought process of why maybe we weren't identified, particularly in the bill? No counties were identified, it was just kind of
No, because it's just about studying Falls Lake in particular, and no reason to exclude Durham County and get them mad. I mean, the way legislation works is you gotta get everybody on board.
Mr. Chairman,
Mm-hmm.
I have a question, this for, probably for the attorney. What's preventing us, are we able to look at legal action against the state and unilaterally with what we're doing right now? And to, we heard the experts say that there was no testing done when they implemented these rules, and to show that that we are working on the getting samples, but that we may not be the cause of this, and we would like the sufficient time to show that we're not the cause of this, and to look at filing an injunction against the state, protecting us from these rules until we can prove ourselves.
As a consultant said, I, like all lawyers, would say the answer is, of course, can file a lawsuit. The question is, can we be successful with the lawsuit? It would seem to me that the lawsuit would be based upon factual information. The question also then is, do we have enough factual information to overturn, in effect, it sounds like you're asking retroactively what rules we have in place. I can't give you a definitive answer on whether or not we would win. I would say that our chances are not great unless we have a base of strong scientific evidence. There is a presumption of regularity on the part of adoption of state rules. So we'd have a fairly large burden to get over. They have to get over that presumption that the rules were made in an orderly fashion based upon the evidence then known. I would not say, Mr. Puryear, that we cannot be successful. We'd have to make some analysis before we decide, you decide, to expend the funds to make that analysis both scientific and legal. Yes, we can file a lawsuit. The question is, and we'd have to examine, would it be cost effective for us? What are the chances of our winning?
Would we need to wait anyway until the middle of the year when you said your report be pretty much complete with all the monitoring?
Well, no, the report, the monitoring won't be done for another 3.5, 4 years. Our report on the BMPs will be there. And if I can just comment on what you said, the state did not act arbitrarily and capriciously. They didn't just make up the rules. They've got a whole bunch of documentation. I'm just saying, I don't think that documentation is entirely accurate. And they did have some data. They didn't have as much data as we'll have. So the argument is, did they act in a way that was reasonable based on the information they had at the time and the charge that they were under? You know, that's a question that courts typically have said, what I said earlier, if the judgment of the agency is based on substantial and reasonable information and they didn't act arbitrarily or capriciously, then the courts don't typically overrule them. If they just made something up, the courts will overrule them if they're just wrong. You know, and so are the rules unconstitutional? Are they inappropriately adopted? Did they not follow the exact procedures they should have done? Those are all questions you would have to evaluate in developing a lawsuit. And, you know, you have to put expert testimony up basically contradicting what the state did. The state's going to put people on there saying we did the right thing. It boils down to a technical argument as to whether the state acted properly or whether it acted improperly on development of the rules. I think that's a very up in the air thing. I think there's...
Is it a factual finding or is it a procedural finding?
It is both. Procedural, did they follow their own rules when they adopted the rules? So you have to examine that. That's one avenue of attack. Did they break their own rules when they adopted the rules? A scientific, factual analysis would be, did they have enough facts to support the rules that they made? And that's where you have to dig into the facts, and were those facts correct? It is not an easy burden to overcome, because you have to overcome, one attack could be procedural. Probably the easiest analysis is, did they follow procedures? The harder analysis is, did they have a factual basis for making the decision that they made? And there is that presumption of regularity that I mentioned. The consultant said it another way, but there is a presumption that you have to show by overwhelming evidence that their analysis was incorrect because of the failure to consider facts or the failure to analyze those facts.
When we complete our project, we will have a new model. We will have a new analysis. We'll have a new tool. And I believe we'll be able to make arguments to show that the rules are overly aggressive and too restrictive. I also think we'll have an argument to say about the question of what is reasonable to do. But at that point, when we submit that to the state and the rules have a provision in it that allows us to submit an alternative, if the state says, well, we're not going to consider that, I definitely think at that point, you're in a position of saying we have superior technical information that should be substituted in place of what the state has in there.
When is that information going to be?
Well, it's going to be another 4 years or so before we have that information. The rules require a certain monitoring period. Going back again, the loads vary every year. I don't like 2006. I don't think that should have been the baseline year. That's going to be an issue too. But we're going to have 4 or 5 years worth of data where we can argue what should be the design year. I think it should be based on average conditions and not worst case conditions.
So this course action will be to combat stage 2.
Right.
Which is the-
All right, now y'all have plans to take legal action once you get your facts in order, or is that something that you provide us with and we do it?
Well, we're gonna have to, at this point, we haven't hired any attorneys. We've been using the attorneys that attend our meetings as general information. The UNRBA does not have a staff attorney.
I want to point out that one of the attorneys that attends that his job is he's the water attorney in the city of Raleigh, am I right?
Yeah.
And he's examined what you're talking about. Some of the questions that Ron's, he's brought up some discussions about that. So, everybody's sort of looked at that. And I want to get back to what Tracy asked about the UNRBA. UNRBA one time was under the RTP group. What's the group over there?
COG, the Triangle J.
Triangle J Council of Governments, and we pulled it out from under that, Tracy, for the very reason that you're talking about. We felt like it was not representing Granville in person, and actually Orange. We felt like and it was one COG board member over there, staff member over there that was trying to do what Forest is doing, and they couldn't do it because they were only allowing them to do that part-time. So we pulled the whole thing out and reorganized it. We got Forest and Jay and them on board to try to do what we're doing now, because it was not representing Person County, and wasn't representing actually Orange or rural Durham, if you don't know the honest truth. It really wasn't doing a whole lot. So, we pulled it out. So the last several years that we've got it out there on its own, is doing what we think it needs to be doing to try to help us. And it's not, it was like we were out there fighting alone with Granville County, with the cities over there, with Creedmoor and Butner and Stem and Person County. We're out there in a battle by ourselves until we did the reorganization, and all of a sudden it's finally figured out that this thing is bigger than all of us. When you start dealing with the EPA and with that amount of water and the impact, we started cooperating instead of squabbling with each other, which is what was going on earlier. And that changed, and I think what they're doing now is headed in the right direction with scientific evidence to do what we're doing. Slow process. I understand exactly where you're coming from with trying to get something done quicker, but, you know, the legislature that was there before Representative Yarber was there was Democratic legislature. I went over there and talked to members of the House, and I talked to people in the environment committees over there, and EPA and the Clean Water Act overrules. And when the Republicans got in the majority, I know Chuck McGrady, representative from Henderson County, is chair of the Environment Committee. I went over there and talked to him. I served on some committees with local government with him, and we've all worked through this. You know, I think things that Representative Yarber's tried with the solar bees thing to see if they were any good. They may turn out not to be. They may be. I mean, you know, I think we're trying to work every avenue we can to try to help us. And I'm not going to pin it on any political group. I'm not trying to do that, because it's not. It's a bigger issue. It's the Clean Water Act, and like he said, they knew the lake was going to be polluted. I was working in Durham County at the health department at the time. I mean, I think some of the bywords at that time was going to be a big cesspool. Well, it turned out not to be anywhere bad as it was originally thought it might be, and it's not anywhere as clean as some people were trying to say that it was going to be. But you know, but I don't know what else to do but try to work through it with the way we're doing it. You know, somebody's got a better idea, we're willing to listen.
Larry, is there anything y'all can do to?
Well, to continue on this discussion, as Commissioner Clayton said, there are political aspects to this. Your most powerful Democrats in Raleigh are the ones that represent Wake County. You also have an Attorney General that would love to have Person County come down here suing Wake County, and he could consolidate all those votes from defending Wake County. So it doesn't make a lot. It's not the right time to be going after that, I don't believe, from a political standpoint. And like I said, I think we're fairly on the right path. I wish it was happening faster. I've had a cold reality in Raleigh that things along this line are not going to happen fast. I mean, I wish I was Senator Rick Gunn right now, but I'm not. I'm a new guy in Raleigh and working my way into it.
Okay.
Mr. Chairman, I will say that my opinion is at some point we're going to have to make procedural and legal challenges to the rules, because no matter what we do technically, the upper part of the lake is going to have growths of algae in it. That lake, you know, Jimmy's talking about being a cesspool. People predict it as a cesspool. That lake is meeting its needs. It really, honestly, if you ask anybody who fishes on it or uses it, it is not nuisance oriented. I mean, there's times when it's full of sediment in the upper end. We know that, but overall, the uses that the Corps intended for that lake are being met. Water supply, flood control, recreation, downstream water quality. They release a lot more water down the Neuse than they used to have down through there. So I think we're going to end up in a testing period to demonstrate that really that meeting 40 in the upper part of the lake isn't necessary to meeting the uses of that lake. And that is a legal process. And EPA is very, very reluctant to approve things like that, and the EPA would have to approve it. But I don't shy away from that. But we do need to complete the process so we've got the best evidence to do that. Because I do think that ultimately we will probably have to push for a different way to look at that lake than what the state's currently doing.
All right, you said that Durham County was taking water out of the lake and cleaning it. How were they cleaning it?
Well, they're using, this is a demonstration, it's really small. You can actually go down, it's right there, right off of 85 there. You can walk.
It's on our website, too.
Yeah, and so there's a little video on the website you can look at. It's pretty interesting. I've gone and looked at it. It's 500 feet long, and what they do is they take this media, which is like a mesh. It basically looks like a mesh, things you put in the rock wall to hold it back, and you put it out in the lake, and you leave it there, and it gets seeded with all of the algae and stuff that's there. Then you take it out and you put it in this trench, this man-made trench, and it's sloped down, and you put a pump in the lake and you pump the water up to the front end of that thing, and it runs down through there. And as it runs down through there, the algae that's on that mesh, that's on that media, takes up the nutrients and grows. And when you go look at it, there's big strings of algae in there. And then when it gets saturated, they take it offline and they scrape all the algae off of it, and then they take that algae and they compost it, do something else with it, move it to Virginia, somewhere, and take it out of the watershed and that removes the nutrients. And the hope is that that system on a large scale would provide a large amount of nutrient reductions that could be used in lieu of building these stormwater ponds and doing other things. I think, at least from a traditional treatment standpoint, I think that's superior to the issue of mixing. But I don't discount that either. I think the representative's got it right. Anything that works would be great, and if it's cost effective and reasonable. But I think this algae turf scrubber has a lot of potential because it addresses the problem directly. And the fact they projected that the cost per pound of removing nitrogen and phosphorus is lower with a system like that than it is through standard stormwater treatment processes. So I think we're looking at all kinds of different alternatives that would work better. And as we shrink down Person County's responsibility, that shrinks your cost. In terms of, if you were, for instance, this is just thinking down the road, if a large treatment system, like a large algae turf scrubber, was installed, Person County could put some money into that with the other people in the watershed, build one, and then they would get their credits from that. That may be a much more cost-effective way than trying to offset credits by building treatment systems on existing development in the watershed. So those are the kinds of options that I think we need to look at. And I think we're making progress on that, but it isn't going to happen overnight.
What if you chlorinated the water?
Well, you can chlorinate the water and you can kill the algae. Unfortunately, chlorine also kills all the other organisms in there too. And right now there's a chlorine limit. If you have a wastewater plant, I guess Roxboro's discharge goes into the tar, but most of them have disinfection. They use chlorinator to disinfect, then they dechlorinate it. But they're only putting a small amount of chlorine. In order to have enough chlorine to kill off algae, you're going to have to hit it really hard. And so you're going to end up with a lot of residue. Plus, when you take organic material and you apply chlorine to it, it creates a lot of bad stuff in the water, chlorinated hydrocarbons. That's the issue that your water plant has in Roxboro, because when they take their water in and they treat it and then they chlorinate it, it creates what's called secondary disinfection byproducts. Many of those are carcinogens, and EPA is talking about controlling those. That's one of the reasons why Raleigh's, they're not as concerned about the algae as they are about total organic carbon. Because when they take in total organic carbon, treat it, and disinfect it with chlorine, it creates these byproducts. Right now, EPA public water rules don't have a standard for those, but they're thinking about establishing a standard. Raleigh was looking at having to spend $200 or $300 million to upgrade their system. That's one of the reasons where they are. City of Durham's already talked to them and said, well, rather than spending $1 billion, we'll help you build that treatment system. You know, the issue again of certain treatment methodology, just like a lot of golf courses uses pesticides in their ponds so that they don't get a lot of algae on them. Most of those have to be labeled just for that use, and to use it on something as large as Falls Lake would be an impossibility. It would just take too much. They've tried that with the Hydrilla project. I don't know, you may have heard about that aquatic weed that got brought in from Asia that's now taking over in certain places. Well, they started doing a program down in the Eno area, Hillsborough, in that area. And actually the state stopped them now because they can't put this material that kills it in flowing streams. They can only deal with it on the sides of the banks in still water because of migrating that pesticide out into the system. So, I mean, there's ways to reduce algae, but those ways of mechanically doing it or addressing it directly in the water, that's why I like pump and treat, because all you're doing is putting clean water back in. I don't even think it needs a permit. The state said it does, but I don't think it does. I think you're putting clean water. If you take dirty water out and treat it and put cleaner water back in, you're not adding anything to it. I don't think that's a waste discharge. But I do think that that's potentially a good thing that we can look at.
All right, well, we're counting on you.
Well,
Yes, sir.
Mr. Chairman, it was touched on briefly, but one of the things that I'm seeing in my office is that you do have a customer service problem. As they talked about, the people are having a hard time getting their projects through, and they're afraid to come out and be identified, because then it'll be even worse. So you do need to look at that and see what you can do for them.
Okay.
Try to get more specifics.
All right. Let's move on to item 4. Volunteer
guys.
Agricultural District Program, Bruce Whitfield.
Yeah, I'm Bruce Whitfield. I'm chairman of the Volunteer Ag District Board. 5 years ago in February, you passed an ordinance that approved the Volunteer Ag District Program. And since then, we have enrolled 116 landowners for a total of 22,500 acres. Some of the benefits that the enrolled landowners receive are increased protection from nuisance lawsuits, and a public hearing is for proposed condemnation of enrolled land, and water and sewer assessments may be suspended or waived if land is in a voluntary ag district, and possible flexibility of city ordinances related to farming operations in a city planning jurisdiction. Our board consists of one member from each township and a member from the Farm Bureau and the Grange. The current board, in addition to me, include Hall Bailey, Brent Adcock, Cal Berryhill, Norman Boyette, Mickey Clayton, Ron Fashee, Johnny Rogers, Chip Stone, Pete Thomas, and Coleman Whitfield. Advisors to the board are Brent Bogue with the Natural Resource Conservation Service, Philip Reams with the Forestry Service, and Charity Silver with the Farm Service Agency, and Kim Woods with the Cooperative Extension. We have signage for landowners. Once they are approved, they are able to buy the signs, and the signs are made by RNS, and the person FFA makes the frames. Letters were sent out to encourage potential landowners twice, the last one being January the 4th, and I was just informed this morning we have quite a few applications for our next meeting. The Volunteer Ag District Program is just one component of the Farmland Preservation Plan, which is currently being drafted. The board would like to thank the commissioners for all your support. Thank you.
All right. Anybody got any questions, Mr. Whitfield? All right. Thank you, sir.
Thank you.
All right. Let's get to the next item, a memorandum on the understanding between Person County and the Person County Little League. John Hill.
Morning, Commissioners. So I'm here to talk to you a little bit about the memorandum of understanding between Person County government, Person County Parks and Recreation, and the Person County Little League. What you have in front of you is a document that states the role between the two partners. Basically, it's stating that Person County government is going to, that we have assumed the property, and then that we are assuming the operations of the Sportsplex, now known as the Roxplex. So our duties are to provide the actual operations of the baseball, softball programming and additional recreational activities to the citizens of Person County and to tourists outside of Person County. And then if you, and that in a nutshell is the duties of Person County government. So if you look at the duties of the Person County Little League, basically they are the 501c3 that is there to help raise funds, have advocacy for the programming, and also, you know, make enough funding to come and help support the operations as a subsidiary. That's it in a
It won't be
nutshell.
like our PCBIC too, or Economic Development Board. because they would do some things that we might not be able to do as a government.
There were two things that under duties and responsibilities that I was looking at and have been a part of voluntary boards dealing with recreation in the past. You tend to have more people wanting things done than actually show up and volunteer. And so I noticed in the duties and responsibilities, we didn't speak to how much or what the percentage of volunteer services is or how much they're required to provide.
You're talking about the Little League itself?
Yes.
No, we did not. And I don't know if you guys, if you want to get into the actual spelling out how many particular hours. I do know that board has a pretty good makeup right now, and they have delegated out duties from, sponsorship chair, concession chair, so there's roughly 12 positions so far being very active on that board. But
Didn't they retain the concession rights?
They did, and the reason they are going to be responsible for the concessions operations, and basically that money that they keep will come back and help subsidize the actual operation of the sportsplex. Say, for example, if they get a concessions vendor that comes in and makes and they make a percentage off of it of $10,000, then they get $10,000 put in their bank account. In return, their responsibility based on Little League International is to put that money directly back into the program, so it can only be used solely for that purpose. But no, we don't have a set amount of hours or anything like that.
I'm not even asking for that, really. What I was asking for is the county has made a significant investment in Person County Little League, and there just seems to be that in the past the volunteer group has dwindled in size, and I think because of our significant investment within the thing that there should be an understanding between us and Person County Little League to provide a specific amount. If we get down to where there's, as I've seen in the past, 4 people doing all of the work for hundreds, then that concerns me. The other thing is, inside here, it doesn't speak to what happens or where the money goes if Roxplex disbands. So that was the two things that I saw in the rules that I wasn't. Because it says they receive and manage funds. We would receive and manage funds, remaining funds from Roxborough Little League, but
Correct.
It doesn't say anything about if they disband, what would happen with it.
Okay, so just recently, you're talking the old Little League that was there running the Sportsplex and initially has disbanded, and that their funding has been turned over to the new Little League board, 501c3, so that their remaining funds that came from the sales of the property and from whatever fundraisers that they'd already done has been transferred into the new Person County Little League checking account, 501c3. So based on Little League International rules, we are a 501c3 under Little League International. So any funding that's in that account or any assets that they have that belong to this new 501c3 under Little League International, if they decide to disband, then it has to go towards any other 501c3 that assumes that position. So, for example,
Okay.
if Person County
that answers it.
Okay.
Gotcha. I got it.
That's it.
Okay. Yeah, anytime a nonprofit disbands, whatever's left goes to another nonprofit.
Correct.
Sometimes you have the right to delegate it, and sometimes you don't, but you can't put it in your pocket.
Correct. And I will say with you charging us with the duties of running Parks and Recreation and the new giving the direction to the new Little League. Say, for example, if it does start to dwindle down, then it's the department's responsibility to create some kind of advocacy to make sure that people are still getting involved and still becoming board members of the new Person County Little League, just like we would do for the Arts Council or anybody else.
How's the construction?
I was called last week by a local industry who's got a foundation who's looking to support some things in the community. Would that be through Person County or be through the nonprofit? If I told about this.
So the way that we handle that, so for example, we operate the Sportsplex and all of its programming. Little League is the nonprofit that helps to subsidize. So basically, if somebody wants to give their donation to this operation, they basically give their money to the Person County Little League. In return, the Person County Little League writes the money back to whatever it takes that they want to donate to. Say, for example, if they want benches put at the park, or if they want a playground or something, and this company or this organization is going to give the money to Little League, and Little League is going to turn back around in partnership with Parks and Rec, and they're going to say, okay, this playground is going to cost X amount of money, and we want this, so we're going to write you a check to provide this particular facility. And we've already had some of that. We've had a donation. We've had a number of donations that have come in to the Little League just recently, and so that's sort of the process that we go. Now, having said that, when Little League, say for example, if somebody wants to give a $500 check in sponsorship of this operation, well, they give it to the Little League, and in return, we have some checks and balances there to where we run it through the county's holding accounts. We account for the money, and then we give the check to Little League. And then in return, Little League meets and decides, well, this sponsorship should be a banner, this sponsorship should be a bench, or blah, blah, blah. Or, they may want to pay into the operation in other ways. So it's got a lot of accountability to it. It's almost too much accountability, I guess you'd say, because it takes a lot to see where those dollars go. But we're doing it this way so that we don't fall into, so we do have total transparency of what's going on.
Move for approval.
All right, any more discussion? All in favor say aye.
Aye.
Any opposed? Item number 6, consideration of grant application for the Person County Sheriff's Office. Captain Kevin Crabtree.
How y'all doing this morning? Here in front of y'all to request permission to write 3 different grants for the Sheriff's Department. All 3 grants are that are upcoming are due by the 31st of this month. The first grant is from the Governor's Crime Commission. It's a $15,000 zero match grant that we would use for some equipment updates, mainly for our tasers in our department. The second grant would also be from the Governor's Crime Commission, which is for body-worn cameras for our officers. It is for every $2 that we put in, they match $1. They're running a special grant. We've had some legislation for larger cities that are starting to require the body-worn cameras. We feel like with them offering this one-time grant that we will probably be seeing legislation to maybe even mandate that statewide before all is said and done. Our third grant we would like to get permission to write for is the Governor's Highway Safety. That's for 6 in-car camera units that usually run about $6,000 a piece, and that is a 50-50 grant match.
So on the body camera is 25. Do we have any now?
No, sir, we do not. We sought out money last year to do that, but as we got into it, the grant we used was too small. The body cameras they're only part of the cost. The infrastructure and being able to retain all the video that comes with every officer wearing a body camera is huge.
So are these like, are they interchangeable? Like, do I get off my shift, take this off, and somebody else use it, or does it kind of like assign to particular officer?
Because of charging purposes, you almost need one for each officer. There's not even a unit out there that covers a 12-hour shift now, but most policies, none of them run the whole time.
Right.
While they're on, you just have to set your policies for when they would be activated.
Right. So, how many, like, patrolmen do you have? Like, this is 25, would that cover pretty much your patrolman shifts?
It would not only cover our patrol, but we would also want to cover our civil, our school officers, not particularly our court personnel, because they're usually under. Eventually, you would want everybody, but you got to walk before you run sometimes.
Right. So this 25, does that cover like your patrolmen and your civil officers?
And our school officers.
Okay. All right. And on the car cameras, are they in every patrol car now, or?
I think we have some in all of our basic patrol units, but some of the units we're using are, to let you know how they're very outdated. The new stuff that we're switching over to actually downloads the material when you pull into the parking lot, if we're ever able to get the infrastructure in.
So these grants are due by the end of the month. When do you think you'll know about them?
The body-worn camera grant, it's on a fast track. We would hear about that from, I think it's the end of April, 1st of March, with immediate implementation. The one for the tasers we would hear from and would possibly go in effect as of July 1st. The Governor's Crime Commission for the in-car cameras, that runs off the federal cycle, so it usually starts October 1st.
Okay. I just actually, I would like to see information to cover at least the ones that he's talking about at our retreat, just to see, I know we want to hear back on some of these grants and see if we could get some help on purchasing them. But I think it protects our officers. And obviously, if they're looking at doing grants for them, then something I think we need to look at doing maybe in the budget time. So I know you can ask us today about stuff on the retreat. So I would request that of the sheriff to see some costs for the car cameras and body.
Captain Crabtree, over the last year, how many instances would you say we've had that we could have used a body-worn camera to help in the case?
I would say,
arbitrarily, a percentage of all the cases that you guys handle, what percentage would a body camera have been successful in helping you?
Well, and it's not just cases, it's citizens' complaints. I can see of an instance where something could have been used almost on a daily basis. Unfortunately, with your in-car cameras, where your car is pointed is all it covers. And so many times what happens is one side or the other. It doesn't ever give you the whole picture of the story. Just like in our research with our body cameras, where to put those so they're going to truly see what the officer sees. We've done them.
They protect the citizen, but this is also to protect our officer.
Oh, most definitely, it protects everybody. And a lot of stats will show that people act a lot more kind when they know they're on camera, and it just creates a better environment.
And I guess what I was getting at is, just like in private business, you have to do a cost-benefit analysis on what you're spending your money on. And I know in one of these grants, the county, it doesn't cost us anything, and the other two, it does, for a total of $48,000. But I just wanted to see how you felt about the cost-benefit analysis of it. So.
How I feel, if it can save just one lawsuit, it will, that $48,000 compared to what you see awarded in lawsuits this day and time would be just a thimble of what it could save us just on one instance. It also really helps when you get into court cases and everything.
How many lawsuits have you had over the past year?
That's above my pay grade. I don't, unless I'm involved, I don't know.
How many over the last 10 years?
Probably 7 or 8.
And what was the cost to the county on those lawsuits?
Most of those were taken care of. 3 of those were detention related.
So over the last 10 years, an estimate of how much counties had to spend because of lawsuits?
I don't see if there'll be any dollars that we have.
None. So really, the cost-benefit analysis, other than us covering the officer, the lawsuit doesn't come into play, really,
Well,
for 10 years.
I will tell you on a personal note, I do the taser training for the county, and we had an incident where a subject I was working for PCC, and a subject got hurt in the taser training, and the subject actually came back and tried to sue the sheriff, the county. He tried to sue everybody in the world, and that was all caught on video, and everything was done exactly right, and everything was thrown out, never proceeded because of video.
But you can see my point, that over 10 years, the county hadn't had to pay anything in a lawsuit.
Yeah, yes, sir, I do. And so much of what we do in law enforcement, thank goodness, is preventative.
That's
You know,
just like saying, well, we don't need to show us on our cars, but they hadn't had an accident in 10 years. I mean, you know.
Yeah, but we also approved
that.
a pay program for our insurance for our employees, and we knew that could cost us more in the long run too. So it's one of those things where you have to look at. We just can't throw money at things just because
I think the sheriff's
we're
department,
county.
and you know, and they probably have had something since you've been on the board, but they've been, in my opinion, very good stewards of the taxpayers' money, and especially some of the grants that Captain Crabtree has written that has actually saved the county money and gotten equipment and infrastructure and things done that didn't cost us anything.
And I agree, but there's questions that should be asked. We don't need to just roll through this.
I understand. But I'll move for approval.
Ma'am,
Certainly.
I will tell you that there's been a lot of instances that I've been involved in on investigations where our officers were accused of doing something that probably easily could have led to a lawsuit. And some of our in-car cameras not only saved the event, to go back and show the person exactly what happened, there was no lawsuit or a complaint filed just based on what the camera picked up. So sometimes you can't always measure things in dollars and cents. It's just like preventive patrolling. You put out there and you divert a lot of crimes from happening, but there's no way to get a dollar value of what you stopped. I think it's kind of the same example.
I understand. And one of the things that I'd like to ask too is with these body cameras, I know that our officers here in Person County would never be held to this, but in some instances, these body cameras have shown that our officers were, or officers within the United States were doing wrong. And so in some cases, you could be used against you. So has the Sheriff's Department thought about instances such as that where the defendant could use that against Person County?
I'd be glad to share that with you.
Please.
I've been doing this for 39 years, and when they came out with car cameras, I said, oh my gosh, we don't need this. This is so ridiculous. But I can go back now, I can tell you that more officers' careers have been saved because of the camera versus, there have been a few situations over my years that the camera cost them their job, but they're no longer out there because of the camera, and don't need to be.
That's right.
But we also got, where we've saved a lot of officers' careers, and you're talking about dollars, you think of what it costs to train an officer, put him out there, and he's out there doing the right thing. That camera is protecting him, and it's protecting the liability of the county much more than we could ever put a dollar value to it.
and also coming from the financial part of it, which I see we come from, our intent is to use the excess that we've gotten off our misdemeanor confinement fund for this year. It was projected to come in at 80,000. It's already at 94,000 with predictions of actually getting up past to cover this match. Most years, as y'all remember, when I come in front of y'all, we've always been able to cover our matches with our drug forfeiture money, but the federal government has seen to freeze our forfeiture money, and we have no indication of when or if they're going to unfreeze that.
Move for approval, Mr. Chairman.
All right. All in favor, say aye.
One question. The 48,000, where would it be coming from?
Is that affecting this year's budget?
It depends on when they get an answer back on needing the match. And if it's in this year's budget, we think we have enough revenues brought in, as the captain was mentioning, from their budget. So we would bring a budget amendment to you for approval at the point that the match is needed, hopefully using their funds.
And only possibility of one of these would come into this year's budget. The other two would definitely be after July 1st. The first one, for the body cameras, we would hear about within 2 months.
So for next year's, we'll put it in next year's budget.
Yeah, we can talk about it. All right, let's get the vote right. All in favor, say aye.
Aye.
Any opposed? All right, Mr. Crabtree, start writing.
Thank y'all.
All right, item number 7, a resolution approving the installment financing contract, deed of trust, and other documents for Roxplex property, various facility and equipment improvements. Amy.
All right. I am presenting to you a resolution that represents the final documentation required for the plan to finance a portion of the acquisition and improvements of the Roxplex property and other various facility and equipment improvements, including the conveyance of North End Elementary School to the county as collateral. The resolution is summarized into 3 main sections. Section 1 states that the county and Board of Education have agreed to finance a portion of the cost of a project consisting of roof replacements at South Elementary, Woodland Elementary, and Oak Lane Elementary, window replacements at North End Elementary School, and chiller equipment replacement at Southern Middle School. The county has also determined to finance a portion of the cost of the project consisting of the acquisition and improvement of the Roxplex property and roof replacement at Huck Sansbury Complex. Section 2 states that the county has determined to finance a portion of the cost of the project in the amount not exceeding $1,884,000 per General Statute Section 160A-20. And Section 3 lists the financing documents that were included in the agenda packets for review, including the installment financing contract between the county and BB&T, the deed of trust which provides for the pledge of North Elementary School as security for the county's obligation to repay the debt, an administrative agreement between the county and the Board of Education which authorizes the conveyance of North End Elementary School to the county and its lease back to the Board of Education, and finally the lease between the county and Board of Education to lease North End Elementary School to the Board of Education for the duration of the loan as part of the financing plan. Further clarification of the stipulations under these sections is included in your agenda abstract for your convenience. I would ask now that the board consider and approve this resolution, which encompasses the approval of all associated documents as presented.
Do I need to recuse myself?
You do not.
He did?
He does not.
He may, if he desires.
He can, but he doesn't need to.
But he is not. Excuse me, Mr. Chairman. I spoke before being recognized, and I apologize.
You have the floor.
The conflict of interest law provides that if a person does not have a large percentage of the stock ownership of an organization for which he works, that does not operate as a violation if he votes. However, each board member has a right to make his own internal consideration and seek the approval of the board to allow him not to vote. Without that approval from the board, he has an obligation to vote.
So what's your desire?
Be on the safe side, I would just recuse myself, if that's at the board's approval.
Anytime you
All
don't
right.
want to vote, I'm for it.
Okay.
Have a motion to recuse Commissioner Perrier. All in favor?
Aye.
Any opposed? All right.
Thank you.
Do I have a motion to approve the,
So moved.
any discussion? All in favor, say aye.
Aye.
Any opposed? The ayes have it. All right. Item number 8, appointment to the boards and committees, Brenda Reeves.
I'd like to present to you a citizen application for the following 2 boards. First, the Economic Development Commission. Nicole Donovan requests appointment to the ex officio, non-voting Piedmont Community College representative of workforce training seat recently designated by the board. What would be the board's desire to make this appointment?
Is she being proposed by the college?
Yes, the college provided the application, and this citizen is gainfully employed in the workforce training department as its dean at the college.
Move for approval.
All right, got a motion on the floor to move. Any discussion? If not, all in favor say aye.
Aye.
Any opposed? Ayes have it.
And then, gentlemen, related to the Juvenile Crime Prevention Council, we have a vacancy created in the seat designated for a person under the age of 21. Ms. Anderson Clayton has submitted her resignation as a student representative as she's unable to attend the JCPC meetings as she is a freshman in college. Her unexpired term is June 30th of this year. So I would ask for consideration to appoint, to fulfill the unexpired term to June 30th, 2016, or consideration to appoint for initial one-year term. We have 2 student applications in your packet, Mr. Tyreek Wright, as well as Megan McCowan. And our JCPC chairman is here, Mr. John Hill, who may or may not want to make a recommendation from the board.
They did not have a recommendation, JCPC.
Okay, do not. Okay.
I don't know either one of them, so I wouldn't.
I'm just going off of the application on it, and there's more listed for Megan. I'm not for what that's worth.
John, wants to say something, Mr. Chairman?
I would like to say that now Tyreek has he has served on the board until we found out what how the positions were supposed to be fulfilled. So he has already been putting some of his time in.
He's been serving since Anderson has not been coming?
Correct. And also I've had discussion with the teacher who put forth Megan, and I said, depending on whatever the board decides to do, both of these individuals will have an opportunity to serve on the board until positions get filled, or not necessarily be on the board, but they can be active in the actual meetings themselves.
So both of them are coming to the meetings?
Well, Megan has not been to the meeting yet. But like I said, Tyreek has been to a couple of meetings and has been engaging in the discussions of the programs.
Move to approve Tyreek.
All right, we got a motion and a discussion. If not, all in favor say aye.
Aye.
Any opposed? All right. Clean Fuel Advanced Technology Grant, Civil Tape.
Commissioners, I'm here to ask your approval to apply for a grant. This is the Clean Fuel and Advanced Technology Grant, and this is available to 24 out of the 100 counties in the state who do not meet air quality standards per the EPA. So we are one of those non-attainment counties. This grant does require a 20% match, and we're looking at 5 different projects to request funds for, and I'll walk you through those projects. They're in your abstract. First is vehicle replacement. We are considering replacing vehicles in DSS as we do each year during that budget process. And so the way this grant works is the county would pay what it would normally pay to purchase a vehicle, but the grant would act as quote unquote a free upgrade to a more fuel efficient vehicle. Now the county would have to pay 20% of that upgrade, but in all the cases that I've looked at, that 20% cost is covered by the fuel savings that we achieve over the lifetime of that vehicle. The second piece of this grant would be education. We're going to get these new vehicles, and so we need to teach people how to drive their vehicles efficiently. The third project would be technology. We were already in DSS looking for some technology that would help us with our scheduling and vehicle usage, and the technology that we're looking at for this grant does that, as well as help us improve our fuel efficiency. The fourth piece is installing an electric vehicle charging station in Uptown Roxborough. This is a project that the TDA is very interested in, and they have pledged money for that. RDG is interested, and the city as well. Of course, they still have to meet with their boards to determine whether they'd be willing to put money into the pot. I've also requested money from Duke Energy. It's my understanding that they have electric vehicles already in their fleet, and so I've requested money from them as well. And the final piece is public outreach. The grant does require that we do let the public know if we receive these funds, and let them know about the types of projects that we are doing to improve air quality in Person County. If you have any questions, I'd be happy to take them.
How much money you talking about?
Well, again, it's a 20% match from the county, so it's anywhere between $25,000 and $31,000. We're still firming up the quotes for vehicles and the electric vehicle charging station.
How many vehicles are you looking at? 4?
Yes.
Yeah, we got 4 coming off rotation on his.
I believe so, yeah.
Possibly. We have to go through our regular budget process where we look at the vehicles that need to be replaced, and Ray Fushi evaluates each of the vehicles that the department submits. So he'll let me know what that final number is.
All right, does it necessarily have to be DSS, or could it just be 4 at random?
It could be any vehicle. It could be any department. We chose DSS because they were already looking at the technology, and so it made sense to keep it in that department. And they do have our largest fleet. The other departments have significantly smaller number of vehicles, but we could do it for all of them, all departments.
So what's the additional cost to the county for the education? I know it says 2 half-day
Yes.
education events, so what's the unintended cost of
Sure.
teaching?
The 20% cost would be $400 to the county.
No, that's not going to take into effect the cost of your employees' time,
That's true.
so it's an unintended cost.
Oh, I see what you mean.
So if it goes to DSS and you've got X amount of number of people that are driving, you got to take them out of class for 2 half days for education. What about the software? What are you looking at as far as the software?
This is technology from a company called Inverse, and it's a vehicle scheduling system. And the way that would save us money is not only through fuel efficiency, because it tracks the usage of fuel. It has safety features if drivers are speeding, it alerts their supervisor. And so, requiring people to follow the speed limit always saves gas. But the other issue is that if they're improper use of vehicles, this would let us know, because it would help us keep track of those vehicles more closely.
What's your upfront cost on the software?
The total is $31,000.
And
but
what's your
again,
monthly fee?
It is $680 a month.
$6.80?
No, $680.
$680 a month.
Mhm.
And the first year, the state is going to pay for the monitoring, and then for 2 years after that, it goes back to the county for a cost.
That's right.
So
It's
$608,000 for the
Per
additional.
year.
Per year. So
Yes.
an additional $16,000.
That's correct.
And I'll just tell you up front, I'm on a board with Duke Energy evaluating software for our fleet, and it's not as easy as the person selling it to you makes it out to be.
Right.
We've had issue after issue for about 9 months now with reporting. The units themselves, when they don't report, you have to have someone from your fleet come in and change those units out. Those units have to be sent back to the manufacturer. There are issues with, if they don't make it back, the company charging you for them. So it's not as easy as a salesman's going to make it out to look. So I just, as a FYI for the board here, Duke Energy, as big as it is having issue after issue with software problems. The reporting part of it is another training that the supervisors have to go to see how to look at the vehicles and hard braking and overrated. It also doesn't keep up with speed limit changes, so it looks like a person speeding in a 45 zone when it's actually a 55 zone, and you have to correct that through the system. The system doesn't do that for you, so there's a lot of things with this reporting software that's not as rosy as the company's going to make it out to be. So not only do you have the cost, but you also have the issues with it. So I'm not a big fan of the software after working with it for about 9 months. So.
Can we leave that part out?
Yeah, you guys can choose to fund or to.
No, I think that's part of the, that's
you
part
want
of the requirements for the grant. I read through it last night. You got, if you get the grant and you pay the 20% and the state pays the 80%, you have to have the reporting software on it.
Right, but we could, if you wanted to, just remove that project completely from the grant application. We can do it that way and just ask for the vehicles and the other items.
I read through most of it, and like I said, I'm not the sharpest tool in the shed, but I thought that you have to report whether you have the software or not. So that would take a person to do the cost saving and the fuel efficiency, and you're just looking at the software so that it'll be an easier reporting system. You would have to designate someone to show over a 3-year period the cost savings on the fuel and things of that nature if you don't put the software into effect.
Right, that's correct, but we already collect that data, so really, it wouldn't be hard for us to do it without the software, because we collect that data through finance and our shell cards, and then we also have a vehicle mileage log, so it wouldn't be difficult to continue to use our paper system to collect that data. But the technology would make that easier.
Supposedly.
Supposedly.
Let's just try it. We might improve this. The
EV charging station, are you looking at a pay-as-you-go system if you get it put in downtown Roxborough, or are you looking at a free system? I know in the past, the EV charging stations that I've seen to get people to using them, they have just put it up and they're eating the cost of it. Is it a charging station that's a per usage charge, or is it a free station?
It would be free, but that would really be up to the city, because we would likely ask them to pay for the monthly electric bill associated with it. So if they wanted to request that it's, one that's a fee-based, then we would write that into the grant. But we're, I'm waiting to hear from you all before they can meet and decide whether they want to pursue it.
And what's the cost of the EV charging stations that you're going to have to put at DSS or whatever location where you're going to park the cars?
The for the vehicles at DSS, it would be about $2,000, and that includes
for one
installation.
station or all the stations?
That's for one station, and that includes installation. For the Uptown station, the total cost is estimated at $16,000, and that includes installation.
But you're going to need more than one charging station if you got 4 vehicles.
Well, 2 of the vehicles are hybrid conversion, and so
they would recharge themselves.
That's right.
All right, do we have to buy an electric vehicle?
Yes.
No, you do not.
You can buy the biodiesel.
That's right.
Now, since I don't have one, you're talking about a Prius?
Prius isn't in it because it's not assembled in the United
That's correct.
States. You can get a Nissan Leaf, you can get a Chevy Silverado EV. It has to be assembled in the United States. And I don't know all of the vehicles, but even if they make the parts here and assemble it in Mexico, it's not available, and you have to have a comparable vehicle. So the Nissan Leaf is comparable to a Sentra if we would buy it, and so you pay the cost difference between the Nissan Leaf and the Sentra, and then the state pays 80% of that cost differential, and then we pay 20% of the cost differential. So
So we still paying the base price for the Leaf?
you're still paying the base price for the Sentra.
Yes.
So if it's $20,000 to buy a Sentra, you pay $20,000, and then $10,000 more to buy a Leaf, you're going to pay an additional $2,000, so $22,000, and the state kicks in $8,000. So I personally am against the whole thing, but and I guess you picked up on that real quick.
That's fine.
So, with the cost of fuel at what it is today, and with technology still getting more refined, I don't want our taxpayers to be burdened with, number one, the regulation, the reporting, the additional cost, when we can go out and buy a cost-efficient vehicle and just run it without having to do all the reporting back to the state.
It's not gonna be that big a fuel saving, that's for sure.
No, the price right now.
Not with the price down like it is. All right, we got a motion. Anybody want to make a motion? I make a motion we not pursue it. Any discussion? All in favor, say aye.
Aye.
Any opposed?
No.
Why don't you make the motion?
Can't do all the work.
I thought I was the one asking all the questions.
All right.
You are.
Chairman does not have a report at this time. Manager?
Yeah, a couple of things, Commissioners. For those of you who haven't had the opportunity to meet our Emergency Services Director, he's sitting in the back, Doug Young. I just wanted to make the introduction for you. He's been with us since December 1st, and he oversees EMS, 911, and emergency management, and is also our liaison with the Volunteer Fire Department. So, welcome, Doug. Remind you that we have an EDC meeting this Thursday. We are being asked by the architect for the Senior Center project to come up with some dates for a public meeting. This would be an opportunity for the public to give input on the design of the Senior Center. So if you have any particular dates in mind, if you could let me know. I think we're tentatively looking at the 8th of February, and I'm assuming that an evening meeting would be better suited for public attendance. We also have a request from the city to have a joint meeting, and Stuart has also mentioned that there is a need for an economic development joint meeting, so I'm hoping to kind of roll those into one if that's possible. The city wants to ask us to partner with their wastewater treatment upgrade.
Why?
They believe that it's an economic development initiative. So that was sort of the impetus for the meeting, but they'd also like to talk about solid waste and the impact of us choosing various options on them. And then, of course, the economic development piece is to hear a report back from a consultant.
Were they willing to participate in revenue sharing?
That is something that we need to ask them. We also have a number of
That's
economic
their
development
request, and
projects.
That's with the wastewater treatment, though, is some revenue sharing, is it?
That has not been
Not revenue
discussed.
sharing, but to
Cost to
expense, right.
Correct. Correct. I think that's a $15 to $17 million project that they're working on, and they'd like us to help them with the cost. So I will come up with some dates that work for you all and get back to the city if you all are interested. I'm sort of wanting to gauge your interest in that joint meeting before we pursue nailing something down. Yes, interested? No.
What? To talk to
Interested
the
in a
city?
joint meeting with the city to talk about.
I'll meet
Yes.
with 'em, yeah.
Okay.
Let me talk with them.
Okay. And I sent the retreat agenda draft out to you. I'm going to try to call you today to follow up on what each of those discussions will look like and make sure that the items on there that you want to discuss as well. I think that's all.
All right.
Thank you.
Okay, Mr. Jeffers, you got anything you want to share?
No, sir. Shocking, isn't it?
It is. I want to ask that question again. Never caught you speechless before. Mr. Clayton?
Yes, sir.
Mr. Breyer?
Yes, sir.
Mr. Kendrick?
Well, since I've been speaking the whole time, I got a few more things to go. I had a library advisory board meeting last week, and one of the things that they wanted me to share with you guys and the public is that they have what's called Fold 3 now on their website, and all you got to be is a card holder for the Person County Library. Fold 3 is an ancestry-based software program where it gives you military records. So different people have gone in through Ancestry and put in pictures of their ancestors that were in the military, their service records are in there, all of these other things. So if you would, take advantage of that free service that's offered by those guys. I met with the Senior Advisory Board last week, and they are very excited about us moving forward with the plans. Maynell met with the architect and gave some of her recommendations, and they continue to look at different things to fund the senior center. And if anyone within the community or any of our county commissioners have any ideas on fundraisers or things that they can do to raise money, they would appreciate that. And actually, for once in my term, I've had someone come up to me out in the public and give praise for the hiring of our emergency services director. He's been out in the community. He's been to a couple of the meetings with the fire departments, and I got some praise from that. So thank you for doing that. We appreciate it. The praise is few and far between, and we thank you for getting us a little bit of it. So.
All right, anybody got anything else? I entertain a motion to adjourn.
Motion to adjourn.
All in favor, say aye.
Aye.
Any opposed? We out of here.
Just taking your spot. There you go.